Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Normally, very recently we have discussed the case law on the false implication of husband's brother, husband's sister-in-law, husband's other relatives. So it is it has become common nowadays. Therefore, people start feeling that Section 498A is being misused most often than nowadays. Very recently, Honorable Justice A. Santosh Reddy held that false implication of husband's relatives will go unabated, will go unchecked if not if not thoroughly investigated. So false implication of the relatives of the husband is common nowadays. So they have to be checked by the court, by the investigating officer also. A classic case I am going to tell you, and the marriage took place in Ongole itself. So it is relating to crime number 203 by 2012, registered under sections 498A of the Indian Penal Code and section 3 and 4 of Dowry Prohibition Act 1961 in Miapur PS, combined state. So 2014 only our state was separated. This is 2012 combined state of AP and Telangana. So Miapur, you know, it is a very developed area near to the high-tech city in Hyderabad city, right? So you can read the case as P.RAJESWARI and others versus State of Andhra Pradesh. So in criminal petition number 6400 and 7242 by 2013, remember 2013, it was decided very recently on 14/7/2022 by Honorable Justice A. Santosh Reddy. So clearly he held that the relatives are being unnecessarily roped into. Now let us go to the facts of the case. If you know the facts, it will be better for you to understand the scenario, the background, right? Actually, this is a private complaint filed before 9th Metropolitan Magistrate Mayapur. So the victim, that is the woman, I should not tell her name, but the marriage between the husband and the victim took place on 14/12/2006 in Gold Merchants Association Hall nearer to Polarama Temple, Ongole. That means the bridegroom belongs to Ongole. She is from Miapur. She is a software engineer. At the time of marriage, 5 lakhs of cash and 25 tulas of gold were given as dowry. Okay, the marriage was done well, and later, actually, after going home, she has come back to the in-laws' house in 2007. Yeah, in 2000 February. She came to in-laws' house at Ongole in February 2007 when husband, her parents, his parents, and his brother as well as brother's wife. So all of them conjointly started harassing her for additional dowry. Of course, she informed her parents. Ultimately, after 2 months, that is on 24/2007, her father came from Yapur and he gave 3 lakhs as the additional dowry. Okay, but still it is not satisfactory to the accused persons, right? So the character of the husband was narrated by her that as he was drunkard and he used to come late in the nights and he used to beat her till the next day early hours and then only sleep. Right. And one day it so happened that the brother-in-law tried to caress her, tried to cajole her, tried to take her into his lap. The intention, here you have to understand the intention. The intention she understood is bad intention. Therefore, she resisted him and she informed the same to the husband, who took it very lightly, and she informed the same to her in-laws, particularly the mother-in-law, who informed the father-in-law. Ultimately, they said, there is no other curve for you. You have to surrender to your brother-in-law. Agreed by this, she could not actually agree for the same, and therefore in the 7th month she returned to Mayapur. Actually, husband left her in her parents' house in the 28/7/2007. So she stayed in the father-in-law's house or in-law's house from February to July. This is the story. So she went back. Later they did not come back. But incidentally, on one day, the wife of A3, wife of Badrav, the husband, then she along with some goons went there and threatened her. Like that, some allegations are made. So ultimately, the case, the police did not take up the case. Anyway, they filed a private complaint. Of course, you know, as per section 156 clause 3, definitely you can file a private complaint. So the charge sheet was also filed. Now, the people, that is mother-in-law Rajeshwari and others, they filed the so-called CRLP for quashment of the petition. First Rajeshwari, then brother-in-law and his wife. So that's why 2 CRLPs have come. Ultimately, going through all these documents relevant to the case, Honorable Justice Santosh Reddy held that the alleged incident that she resisted from the clutches of her mother-in-law, which occurred prior to 28/7/2007, was not at all informed to anybody. She is a software engineer. She is from Hyderabad city. After all, they are from Ongole, which is a small town. So definitely she would have raised up alarm. She would have definitely given a complaint on the incident, at least in Hyderabad city, which she did not know. So she is a software engineer, and she would not have kept quiet till 12/6/2007. So therefore, even then, keeping her in his lap and cajoling her does not come under 354 IPC. So definitely it is a foisted case in the opinion of the judge. I am telling you, please remember, this is the opinion of the judge. So he thought it's a fit case to be passed under section 482 CRPC. So nowadays, that's why please remember, when things are like this, normally even the judges are also not believing the versions. They are not able to digest these versions also. Maybe true. We can't say that is totally untrue or brother-in-law is a nice man. But what court wants only evidence, that's all. Doesn't want whether she wept or whether he wept, all these things or not. Whether is a fit case to be coming under the purview of section 354, that is outraging the modesty of a woman or not. So nowadays the blanket accusations, omnibus allegations against the in-laws has become common. So therefore, 41A, Arnesh Kumar judgment, you know. So while deciding the case of Arnesh Kumar, Honorable Supreme Court of India clearly stated that the investigation should be thorough. The investigation should probe into the involvement of the other accused persons. So not use the power of arrest arbitrarily. So since you got the power, you cannot arrest each and everybody. That's why in CRPC it is clearly said that the investigating officer may arrest. The investigating officer shall arrest and rayaledu. Right? So take into consideration of all these things, the judge ultimately quashed the FIR. So this is a classic case where misuse of 498A is observed quite often than not nowadays. But friends, remember, in my personal view, such things may happen. The brother-in-law may have an evil eye over the sister-in-law. The father-in-law, for that matter, I have seen cases where the father-in-law had evil eye over the daughter-in-law and he tried to actually sleep with her, which she resisted. These things do happen, but not common. Now and then, or occasionally, or once in 1,000 cases may happen. It may be true also. We don't know whether it is true or not. But the omnibus allegations are not believable. That is what is held by Justice Santosh Kumar Reddy in this case. So please read the case law and enrich your legal knowledge. The case law is P.RAJESWARI and another versus State of AP and another in CRLP 6400 and 7242 by 2013. Right? Thank you.